Welcome, everyone. We have the pleasure to have CASHFLOW, Gary Davidson, founder of CASHFLOW, and today's topic is how to stay out of the contractor's disputes and mechanics liens. So thank you and welcome, Gary. If you would like to introduce your team, that would be great. Sergio and Brian, welcome. Thank you for joining today.
Thanks so much, Hugo. So we got a little bit of a smaller group tonight, so we can do this interactive and go as long as we'd like. My name is Gary Davidson. I own CASHFLOW. We're the largest real estate investment law firm in the state of Illinois. But beyond that, we have about 15 or 16 attorneys servicing clients all the way from ExxonMobil to banks, hedge funds, private equity groups, investors on evictions, lots of corporations, restaurant groups, municipalities. We do land use zoning, pretty much anything with the exception of divorce, personal injury, criminal law, bankruptcy. So all of those sort of commercial or all those sort of consumer type practice areas, we don't do those. But what I'm most known for is that I have the largest base of investors in the Chicagoland area. We'll close about 2,500 to 3,000 real estate transactions in 2022. To give you context to that, the next closest attorney that's doing investment work might close 600 or 700 closings. So we represent a company called New Western. I just want to put in a plug for them, and then we're going to get into today's topic. The reason why I'm introducing that client's name to all of you is because they're actually the largest wholesaler in the United States. They purchase with their own cash about $2.3 billion worth of property. I am their exclusive attorney in Illinois. We've got now 2 offices in Illinois, and we expect that by the spring of 2023, we'll be closing approximately 50 to 75 assets a month in Illinois. And why am I bringing this up? For those of you who are investors who want to wholesale properties, we will buy them. For those of you who are investors who want to find assets or properties, we will sell you the assets. Because we're spending tens of millions of dollars on a monthly basis throughout the United States, we have the most comprehensive direct-to-seller marketing because of our buy or because of our spend. So if you go on to if you Google New Western Acquisitions, you can see that we're in almost every major market in the United States: Phoenix, Atlanta, Fort Lauderdale, Florida, all the typical places that you might find: Chicago, New York, LA, all of those locations. So if you're looking for investment properties, if you're looking for properties where you want to have Airbnb, we can get assets to you, and we can also buy the assets from you. And when I say we, what I really mean is my client, because I am their attorney. Now, what you all joined me for here tonight. I don't know how many people are buy and hold people, how many people are flipping properties, how many people have bought and sold a lot of properties, or for those of you who are new. But everything that I'm going to be describing to you this evening is going to be applicable. Hi, Lisa. Sorry I didn't connect with John today. Everything that I described to you in the next 45 minutes is going to be applicable to whether you're a new investor or you're an investor that's bought hundreds and hundreds of properties. And what we're attempting to do when we're running a successful business is we want to minimize our risk and we want to maximize our return. Whether we run a hot dog stand, whether we have a real estate investment company, whether we're a physician, whether we're a mortician, we want to minimize our risk and we want to maximize our return. So avoiding contract disputes and bleeding green, as they might say, is about minimizing risk. And so when we start first getting involved in investment real estate, we're running around 1,000,000 miles an hour in no particular direction. We're very, very excited, and it's the little details that count, repeated consistently, that will yield a consistent product. So you can't hit a target you can't see. If you start to build a product without reading the directions, you're probably going to end up with a product that is not completed properly. And so what happens is we buy an asset, we run out and we hire a contractor, and the typical investor will meet with a contractor, and they'll say, you know, how much does it cost to rehab this house? And the investor will say, you know, or excuse me, the contractor will say, well, it's going to be $40,000 to rehab this house. Both parties will think that they have an agreement. Now, if you had to think about it, okay, if you had to think about it, what meeting of the minds is there if someone says, I will complete the rehab on this house for $40,000? What does that mean? It means something totally different to the owner and to the contractor. What type of light switch covers are you using? What type of tile? What type of appliances? What's the scope of the rehab? What's the budget for the rehab? What type of products are going to be used? Are we replacing air conditioners? Are we not replacing air conditioners? So I would say one of the biggest sources of phone calls that I receive from investors is that they get a phone call and say, my contractor ripped me off. You know, they're only halfway done. I'm fighting with them. They're not completing the job. We also represent a lot of contractors, and we get the same phone call. The owner's totally unreasonable. You know, they're not willing to pay me anymore. I've got $40,000 in overages. And when I ask them to produce the agreement, one of two things happen. Either they can't produce an agreement at all, or they produce an agreement that is no more than 1 page long, and it says, you know, cabinets, sinks, tile. There's no SKU numbers. There's no scope. There's no time frame. There's no penalties for completion. And so what happens is, generally speaking, I would say in probably 80% of the cases, neither the owner or the contractor are inherently bad people. Certainly, there are bad contractors. I mean, thank God for contractors. If contractors didn't exist, certainly lawyers would have the worst reputation in the world, but we have contractors, so now we're not quite that far down on the totem pole. But the reality is that the parties didn't have a meeting of the minds. So in order to avoid contractor disputes, put very, very, very simply, we need to have a written agreement that covers specifically the scope of the rehab, the time frame of completion, and a total budget for that rehab. We need to confirm that there's insurance policies in place. We need to confirm that they're going to provide us with mechanic lien waivers, waivers of claim. We need to provide that they're going to give us receipts. We need to know whether this is going to be a contract which is a time and material contract, or is it going to be a cost plus contract? In other words, I'm going to rehab your property for the actual cost of the labor and materials plus 15, 20, 25% as the general contractor. So one of the things where we can avoid contractor disputes is, let's spend a minute on how mechanic liens work. So a mechanic lien is not technically, the term mechanic is simply meaning anyone who provides goods and services for a property, whether it be commercial or residential. And in order to, for a subcontractor to collect their money, if they are hired by a general contractor and are not paid, they have a lienable interest in the property, meaning that if you have a contract with corporation ABC Builders for $50,000 and you don't collect lien waivers from the electrician, from the plumber, from the carpenter, from the HVAC guy, from anyone else who is a subcontractor, you can and very possibly will be required to pay twice. Because if you write a check to ABC Contractors for $50,000, it is irrelevant to defeating a lien claim where a contractor places a lien on a property where they have not been paid. Again, let me repeat, if you spend $50,000 on a rehab and the contractor fails to pay the plumber, the electrician, the HVAC guy, and they all file liens on your property, and you go in front of a judge and you say, hey, Judge Smith, I paid $50,000. That was my total contract. And you do not have lien waivers. The judge will say, well, I feel very sorry for you, but the mechanics lien statute does not afford you the protection of saying I paid the contractor. It is your responsibility as the owner to collect lien waivers from subs. You've ever heard of the term borrowing Peter to pay Paul? Contractors invented that. So they're using your funds to pay to complete projects that have happened in the past, and then they fail to pay their subcontractors. So I highly recommend for construction projects that you run all of your draw payments. If you don't have a construction loan through a bank, and if you're doing this with cash, because the bank's going to make sure that construction draws are the title companies collect the lien waivers. But if you don't have a construction loan, I would highly recommend setting up through a major title company such as Chicago Title or Fidelity National Title, which have large construction departments, a construction escrow where you'll make your payment directly to the title company. The title company will then collect all of the lien waivers, and upon the subcontractors supplying the lien waivers for the services and the products that they provided, then the title company will issue them payment. The beautiful thing about construction escrow through the title companies is it's almost the cheapest form of insurance. You're going to probably pay about $250 for draws. So on a typical, one of these small projects where we're buying a house for $100,000 or $150,000 and putting $40,000 or $50,000 into it, and I consider that a small project. You're probably spending about $500 to $750 on having a title company handle all of that for you, so that you don't have to be bothered with trying to figure out whether you got the proper payments. With that being said, I want to just spend one second saying that for those of you who have specific questions, I believe there's a methodology for you to type your questions in the sidebar here, and I'll review those questions and try to answer them. What's wonderful about tonight is that questions and answers are free. Once this webinar is over with, questions and answers will cost money. So very seldom are you going to have an attorney that is going to provide free legal advice, but I will be doing that tonight for those of you who have specific questions. I've also got on the call here tonight, so I'm the owner of CASHFLOW. I also had our real estate practice group, and as I mentioned, I represent a lot of hedge funds, private equity groups, investors, and banks and private money lenders, hard money lenders, and whatnot. I've also got two guys from my litigation group, Brian and attorney Brian Krause and attorney Sergio Lopez here. Brian, let me bring you on here a second. What are some of the things that you've experienced with court and some things that we have currently pending that are mistakes that clients have made, which now have allowed me to pay for my daughter to go to Tulane University at 90 grand a year? And what are some of the things that we have pending right now in our office that would be good examples of things where people might benefit from trying to avoid circumstances that other people have found themselves in?
Oh, very good question, Gary. And that's the kind of question that could end up making this webinar go all night. So I'll be brief. Just a couple examples. One point that you hit on that I think is huge, and it's something that just a lot of people, if you're not a lawyer, there's certain things you don't think of. That's why we do these webinars. We try to point out things that you're not going to think of when you hire someone. I mean, I have a lot of folks, they get a little 1-2 page contract put in front of them. It looks pretty good. I mean, it lays out a price. Usually it generically describes what's going to happen. And then as things start to go, as work starts to get to be done, well, certain things come up that nobody expected. I had one here recently where a homeowner ordered wanted some siding done. Pretty good company doing the work. The siding was hardy board siding, which for anybody who does a lot of this, hardy boards, common type of siding that people will order. But what did they do? Well, they subcontracted it out to some crew that didn't have experience. Well, they dented her gutters. They messed up her cameras. They brought in materials that were substandard in her opinion. She didn't like the way it looked. It wasn't even, et cetera, et cetera. Well, there were inspections that were missed from Will County. So the point, to make a long story short, the point you made at the beginning, you've got to get these specifics in the contract. You've got to have in there what you want. If you don't want it subcontracted out, you want a particular party doing a particular type of work, that's got to be in there. Some other things I would advise, some other situations I've run into, and I do this on both sides of this, but when you've got, I've had situations too where a lot of people, if you're not familiar with how to do the lien waivers, a lot of people don't like to get into that. They don't really know how to do it. And they figure, well, especially if it's someone someone you've known for a while, oh, what's the big deal? It's a family-run company. They're going to do a little bit of work around the house or whatever. Well, I've had situations where client hires a party to do some remodeling. They know the people. It's a family-run company. They don't do a lot with subcontractors. I had one where a guy hires his sons to do some stuff. Well, then he gets in a fight with his sons, right? And he doesn't pay his sons. And you're thinking, okay, well, what's the big deal? I've paid and everything. Guess what? His sons can put a lien on that property. And you have situations even where people don't do their liens correctly. Here's another situation I run into. This reminded me of this too. In order to do a lien properly, there's various steps you have to follow, right? Well, even if a party doesn't, a contractor or subcontractor doesn't do their mechanics lien correctly, if they've got that mechanics lien on file with the recorder, you've still got to get it removed if you want to sell the property and not have issues with the title company, or whatever you want. Either way you look at it, it's a cloud on title. So then you've got to go. You have to take it to court. You have to file. You have to send certain notices. You have to take it to court to get the lien removed. That's a situation I've run into. I've run into, here's another situation. I've run into a situation on the other end. We're representing the contractor where they sign their lien waivers. They give them to the property owner, but the property owner made a lot of changes, a lot of extras. Well, now my clients are upset. They want to be reimbursed for these changes, but they didn't do proper change orders. You got to do your change orders if you want to get reimbursed for this stuff. So there's a lot of moving parts to this. There's a lot of boring, intricate attorney stuff. My philosophy is if you get your attorney involved early, you help avoid some of these mistakes that end up being much bigger mistakes later on.
So I know Sergio just took a bar exam not too long ago, so he actually knows the law better than Brian and I. With a lawsuit or any sort of contest of a contract, if I remember correctly, back from when I took the bar exam 25 years ago or so, there's 4 components to being able to prove a case, right? It's duty, breach, causation, and damages. Don't I have that right, Sergio?
Yeah, that's exactly correct.
Okay. Go ahead.
Yeah, no, I was going to say that's exactly correct, and it sounds like a lot to prove, but you'd be surprised how easily a contractor can show that in court. As an owner, you can get kind of blindsided by the fact that it's so easy for the contractor to come in and say, look, I was hired to do this one thing, I did the one thing, so what if the owner didn't like the way that it came out? They never specified that they wanted it to be done a certain way. They just said, please, change the toilets, or please, fix my roof.
So let's just start with number 1 for people, because again, whether it's a joint venture agreement, whether it's any sort of co-ownership of a property, dealing with multiple parties, the best partnership is a partnership of one. But when we're buying properties with people, when we're engaging with contractors, half of marriages end in divorce, and half of business relationships end in divorce. Half of investor relationships with their contractors end in divorce. Half of partnerships with properties end up in divorce. And again, the reason is we have to start with these 4 things: duty, breach, causation, damages. Now let's break those down for a second, because if everybody hasn't taken away anything from tonight, understanding how these 4 things work and how they are the only things that are ever going to matter in your life when it comes to enforcing contracts, or telling somebody that somebody treated you unfairly, or he thised me, or he thatted me, and he ripped me off, and this guy didn't do this. We have to establish a duty. We have to establish a duty to do something. And if we don't have things in writing, and we don't articulate exactly that which they are to do, it is a legal impossibility to establish a duty. Because how is it that we're going to establish a duty if we can't prove it? That is called 2 parties in Judge Wapner's court saying, he promised to do this, well, I didn't promise to do that, and then it's judged based on the credibility of the witnesses. But if you have it in writing that they were to order 23 square feet linear of cabinets, model X in chocolate brown, and they were to be installed on or before August 1st, and the total purchase price was $3,500, then that it's very crystal clear what that duty is. Sergio, did I kind of outline that okay, or what do you have to add?
Yeah, no, I think that's perfectly said. You can't exactly say that the contractor didn't do something if you can't prove that they were supposed to do that thing. So the more specific and the more concrete that the contract is at the beginning, usually can avoid all of the headache of court. And I think we've both kind of talked about it already, but the majority of the clients that we get, when we take a look at the contract that was signed, it doesn't have those specifics. And I can understand and appreciate how maybe at the very beginning it might seem like almost an unnecessary expense to have to hire an attorney just because you want someone to go fix something on a rehab. But you hire an attorney when things go wrong, but you could have just as easily hired an attorney in the beginning and nothing would have gone wrong. And it's a lot cheaper to do it that way than to wait until you're in court. So that's absolutely correct on having to be specific in the contract.
Certainly, I mean, these things, we're not creating them from scratch. I mean, these are documents that you guys can provide to people that they can use over and over and over and over again. The analogy that I like to use is when the United States and the former Soviet Union were trying to get to the moon. They didn't operate on a strategy of hope. They didn't, make a picture made by a 6-year-old on a piece of paper showing a rocket going to the moon. They drafted it out. They hired scientists. They hired engineers. And they were fairly certain before they put humans in a rocket ship that they were going to make it there. Now, things happen. However, if all goes well and the plans are followed to a T, one would hope that we can make that rocket ship there and back. Same thing with houses. The reason that we are all involved in real estate is because we want to create a life worth living, a legacy worth leaving, a business worth owning, and that legacy worth leaving to the people that we care so deeply about. And so if that's why you're in real estate, if that is your why, that you want to have residual income, that you don't want to be punching a clock, that you want to have a life that's worth living, because life's not a practice round, and that you want to have that legacy worth leaving, don't you owe it to yourself to make sure that you exercise that general concept that we've all heard, which is an ounce of prevention is worth a pound of cure. So being very, very, very specific on the front end, taking your time. Our parents all told us, take your time. Take your time with this, because this is involving a lot of money, and it only takes one error for a lot of us. One error to lose everything. And I'll tell you, coming from just a place of vulnerability, I haven't bought a residential property in probably, I don't know, eight or 9 years. I was buying a lot back in 2005, 2006, 2007, 2008, 2009, 2010. Probably 100 properties I bought and sold in a 5 or 6 year period. Lots and lots of projects going on. And I too, I was the shoemaker that was shoeless. I had a client that went to Tennessee. They lost everything. They needed money. I said, come on up. This was when the market collapsed, and I was buying properties like a crack addict because they were, I was buying houses in Plainfield for $60,000, for goodness sakes. Had I kept them all, I should have followed some of the local gurus that talk about buying holds. I was flipping everything thinking I was smart, but I should have probably held on to them. I wouldn't be on this webinar right now. I made plenty of money. It's just that I didn't see any appreciation. But even myself, I went too fast, too quick, trusted people, and I paid a guy, I think over $100,000, and he was gone. This is a person I knew very well, somebody who I viewed as a friend. But it's amazing when people are in bad spots, they have a tendency to justify their bad behavior. And so he probably saw me making lots of money on flipping properties, and he thought, well, gee, Gary doesn't need the $80,000. I need it more than him. So, you can't be too careful. I mean, trust but verify. And we need to have these things in place because I said duty, breach, causation, damages. Well, so we now know we have to have a duty, and we have to be able to prove that a person had a duty to perform, both a duty to pay, a duty to perform on time, a duty to put in the product that we've both agreed has to go in, the type of marble, the type of hardware on the cabinets. And again, for the most part, we're not building the Trump Tower. I'll use some other building just because I'm not trying to be politically volatile here. But we're not building the Sears Tower, to date myself, or whatever it's called now, the Willis Tower. We're buying and selling a residential property. So for the most part, in order to be successful at anything, we have to deliver a consistent product consistently. So when you say, gosh, that seems an awful lot of, it's great, Gary, that you're saying that you need to be very specific and put SKUs down and, say the total number of receptacles and GFCI outlets and the exact type of hardware, but that, I mean, I'll never be able to do but one property a year. Well, you know what? These properties, they're all the same. Yeah, they're different shapes and sizes, but for the most part, we're going to put the same products in. When I was doing it, it was, the chocolate browns, and now it's the grays and the blacks, and that's all hot. So use the same luxury vinyl tile. You know what the prices are on that. Use the same marble. I mean, people, 90% of the people want the same thing because they want what's in style. So it's not that difficult to start to hone in on this and just keep that product consistent, because you're not living in this house, someone else is. So, it doesn't matter whether you don't like it. I feel like I'm getting off on a tangent, but I mean, I'll never forget the property I bought in Homewood, Illinois. And this property is those of you who have bought in Homewood out there, they have a lot of these homes that have a one-car garage attached with that flat roof. So you got the gabled front house, and then right next to it is this like box. I mean, it's ugly as hell. I mean, it is the most ugly shit you'll ever see in your life. And I thought, I'm not going to buy this. This thing is ugly. But you know what? What I forgot was that it doesn't matter what I think's ugly, because there was a buyer for that house, and a lot of people wanted to be in Homewood because of the school district. And I never made more money than I made on that house that I thought was ugly. So we need to be looking at these things and buying assets like we're trading stock. And I'm going to get back to contractor disputes in a second, but if you just allow me to finish my tirade. Think about buying assets like you're buying stock, meaning that you should be able to buy them blindfolded, because it doesn't matter if you have some moral objection to smoking. If Philip Morris is doing good, then, that's the stock you buy. Now, maybe you have some things that are, no-go zone, where it's like, I don't care how good this is, I'm not going to do it. Fine. You don't want to invest in, brothels or marijuana or whatever, that's your business. But for the most part, we should be able to buy assets blindfolded. And the last 50 to 60 properties I bought, I never went to them. I never looked at them. I never saw them. The most success I ever had was I based it solely on math and numbers. And what is the asset that I can buy it for? What's the after repaired value? Boom, done. Didn't care where it was, what it looked like, because what I found was I'm a lawyer. First generation, my dad was an assembly line worker at CAT. My mom was a secretary. I wasn't born with a spoon in my mouth. But at the end of the day, I'm a lawyer. So I would drive, at the time, I think I lived in Shanahan. Now I live in Homer Glen. But I would drive to these houses, and I would drive 45 minutes to an hour. Charlie, be quiet. I would drive 45 minutes to an hour, and I would get there and I would say, it's a house. Like, what was I supposed to do? Like, yeah, it was another house. I mean, what possibly was I going to do at this house? So anyway, I talked about duty. I talked about breach. Brian, can you spend a minute on causation while I go lock my dog up in its crate?
Sure, Gary, I can take over. So, and just following up with where Gary left off. So, you have a contract, you've got a breach, and then I actually add one thing to that too. You've got to the plaintiff has to show that they've performed all the terms of the contract as well, and then from there you've got to show that the breach caused a specific amount of damages. So, for instance, if you have a contract says that the contractor has to use a certain kind of material, maybe it's on the cabinets, maybe it's on something, maybe on the island in the kitchen or whatever. So you got clear terms in the contract. The contractor doesn't do it. Maybe they try to use some kind of substandard material or material that's of less value than what you wanted in there. What you have to do then is you have to show your damages, and you have to show that you performed under the contract. You have to show that you paid whatever it was required that you had to pay, whatever your obligations were under that contract. You got to show that you did that. And then, so for instance, how would you show, for instance, what your damages were? Well, you'd have to present evidence that whatever material that you wanted was worth more, and then try to show what the difference was between what the contractor actually put in the property. That would be an example of your damages, and showing how the breach caused those damages.
Perfect.
Yes. Welcome back, Gary.
Thanks. I just put my firm website, my cell phone number in the group chat. You're welcome to call my cell. I'm rarely, if ever, in the office, as Sergio and Brian will acknowledge. So always just feel free to call me on my cell phone with questions. Sergio, will you take a stab at damages? Is a pretty easy one, obviously. People can be righteously indignant. People can think things are terrible, but if somebody goes beyond the time frame of a contract, but we have to be able to identify what those damages are and define what those damages are. And if we put in the contract that it's a per diem penalty for failure to deliver a certificate of occupancy, that might be the best way to establish damages, perhaps, right, in a contract?
Yeah, I would say so. And the reason for that, again, is because it can be kind of hard to prove that you were harmed and that you were harmed a specific amount because of what the contractor did or did not do. But if in that example you have a per diem where if the project was supposed to be completed by August 1st and each day that it wasn't, there was going to be a fee, and now it's August 10th, well, you were damaged, and guess what? You've got proof that you were damaged that amount of money for each day that the project was not completed. And it can be really hard to prove something like that unless it's written in the contract.
Hugo, do you have kids crawling all over you, or are you actually listening to us? We'll see if he's actually here.
Oh yeah, I'm here.
Okay.
Yeah,
Well, Hugo, what's some of the things, because I know you've done so many projects that have been so helpful to people and have provided such good resources and learning material through DealVault. DealVault is such a tremendous resource for people. What, you know, and so people call on you all the time with problems. And I know you've even called on me with a couple problems.
Absolutely.
What are some things that you've seen where you think maybe we haven't really covered that people could benefit from?
So I would say what's really important, I mean, first of all, working with contractors is the biggest nightmare of all investors. So we really need to make sure that we vet them, that we, as you said, have the lien waivers ready. And most importantly, we need to hire licensed and insured contractors instead of handymen to do projects. That's very critical. So
Now,
that's also.
on
Go ahead.
DealVault, Hugo, I know you have recommended things for attorneys, title companies, lenders, et cetera. Do you have a tab for contractors?
Absolutely. Yeah, we do have contractors that are licensed and insured, which is very critical to work with insured and licensed contractors because they can pull permits, they do work up to code, and that's critical. Handymen are meant for maintenance and upkeep, but we really need to work with professionals when it comes to rehabbing properties. Projects over $10,000, absolutely. And then with today's market condition, we just need to make sure that we take on light to medium rehabs, nothing over 75,000, because then it gets too expensive. We open up too many cans of worms, and right now, properties are not selling due to the high interest rates. But again, going back to contractors, we just need to make sure that if we're going to be working with a new contractor, that we give them a small piece of the project instead of the entire project up front, so that we can test the waters, find out their time frame, quality, pricing, okay, before we give them an entire project. So that's been our experience, to avoid getting into lengthy rehabs, not good quality, right? And then going over budget. So we just need to make sure that we work with trusted, already vetted contractors that are licensed and insured.
Okay, and so you made me think of a couple of things there, Hugo. Thanks for
Yes.
chiming in there. One of the things is, again, when we're talking about minimizing risk and maximizing return, and again, this is the key to every business. We want to minimize risk, maximize return. Pulling permits. This is a big question that people talk about, and contractor disputes. I know both sides of this, and I recognize that there is a strong desire from a timing perspective, especially when we're looking at properties in the city of Chicago, to avoid pulling permits. And I get it. You know, sometimes people say lawyers live in a perfect world, and that perfect world doesn't exist because as investors, we need to turn our product, right? Here's the risks with failure to pull permits. And I'm not suggesting, well, first of all, I have to tell you, as a lawyer, I have to tell you, you've got to comply with the law, and you always have to pull permits. But for those of you who just choose not to pull permits, I want to just sort of give you some reasons why you may want to reconsider that. Virtually every attorney review letter that I get, thousands a year, from buyers, will have one of the 15 or 20 or 8, depending on the attorney, questions in the attorney review letter was, were permits pulled? And so we have to answer that question, right? So once we say that permits weren't pulled, then we are faced with a little bit of a problem from the perspective that number one, we could lose our buyer. But number two, what I've seen happen is all of a sudden, armed with that information, you, as the seller, could potentially be held hostage by your buyer. Because people are not nice and sometimes they're nasty. And if they want the house and then you deny having a whole new roof put on because it's ridiculous, because the home inspector, who is garbage, looked at the roof from the ground because he couldn't get his fat ass on a ladder to climb up on the roof, and said that it might be beyond its useful life, and the roof's probably 5 years old, and we all know they last at least 15 or 20 years. Well, all of a sudden, they're all pissed off because you don't give them 6 or 7 grand, and next thing you know, they're calling the village. The next thing you know, you're tearing out all your drywall because they have to do inspections on the plumbing, the electric, et cetera, and then the inspectors are pissed at you because you tried to pull one over on them, and then they really jam you. So the risk associated with failure to pull permits is very, very high if you get caught. Now, you could probably do it 6, 7, 8, 9, 10, 15 times, never have a problem. But the one time that you do, it literally can cost you hundreds of thousands of dollars. Generally speaking, there's one way to do things in the world. It's the right way. So we try to encourage people to do things the right way to, again, minimize your risk and maximize your return. Shortcuts ultimately can become the long route. There's a reason that if you ever played the game of life and you choose to either go to college and get the degree or you go the short route gets you around the board quicker, but your salary when you're hitting your spaces is much less, and usually the person that went the long route ends up ahead. For those of you who played life. If for those of you who didn't, you won't understand my analogy. Brian, Sergio, what else do you got?
Just
Brian,
the last note that I would.
Hugo, have I missed? I know I'm talking in very, very, very generic terms. I was hoping to see some questions on the side. I don't see any questions on the side. I do want Brian to give a really very, very brief update on, because we have about 5 or 6 more minutes here, very, very brief update on state of evictions in Cook County and the surrounding counties, because we're now about maybe 9 months past Governor J.B. Pritzker's illegal and unethical orders regarding COVID that prevented people from filing evictions who all needed to have rent money paid. And so what's the status of evictions in Cook and the surrounding counties, Brian?
Oh, thanks for asking, Gary. Yeah, just real quick, evictions are one of the many things that I do at Castle Law as well. I got my start doing commercial evictions. I do commercial, residential, been doing it 10 plus years, so I'm always happy to help folks out with those. Here's the state of evictions. They were never great in Illinois, but they've gotten substantially worse. The biggest thing that has made the time frame on these go up is that now they're trying to push mandatory mediation. And the reason they're doing the mandatory mediation is there's just so many cases. People try, for a year and a half, they couldn't file them. So the system's really being overloaded with so many of them. I'm preparing a timeline as a courtesy for my clients, give them an idea of how long it's going to take. In Cook County, I tell people on average in court, you're going to be waiting about 5 months if the case doesn't settle. A part of that is because there's a mandatory, what they call early resolution program. It's Cook County's version of mediation. So you have that to contend with. In the collar counties, it's a little bit less. I tell people, on average, you can count on about 3 months in court. In the collar counties, mediation, depending on the type of case, mediation is often mandatory as well, and that's what's causing a little bit more of a delay in these cases. Regardless, this is another area. I mean, this kind of ties in with some of the stuff Gary was saying, but contact us before some of these problems happen. If I can get involved in a file before we're in court, I can always not always, but usually make things a lot better than once we're at the point where we have to go to court. Some other things you should be aware of for Cook County. I know a lot of investors. I know a lot of landlords, some of them very sophisticated people, some of them very successful, some of them with big portfolios, commercial, residential. I still run into people, though, who don't know about the Cook County Residential Landlord Tenant Ordinance. This is a new ordinance. It was passed about 1.5 years ago. I run into a lot of folks in Cook County. Their leases they're not in conformance with this ordinance, and by not having your lease in conformance with the Cook County RLTO, you're putting yourself in a position where you could be subject to fines and other remedies. Tenants can get out of their leases a lot easier. So please, if you're in Cook County and you're not familiar with this, contact me. I can help you get yourself back on track with that.
Awesome. Brian, I did get a couple of questions here. I'm going to just answer them. So first and foremost, guys, if you look on the side screen there, you can put my email address up there. If you want to send me an email, request my form, our form lien waivers package will give you a lien waiver, subcontractor, general contractor lien, final waiver of liens. Normally we charge $500 for that lien waiver package because I like Hugo and he's such a good guy and he's such a giving person. And because you all have had to listen to me drone on for an hour, if you email me, I'll give those to you for free. Just give me a day or two to get them over to the paralegals to assemble all that stuff for you, and then we'll email those out to you. Rich, I know you said you're going to email contractors for lien waivers. We can give you those lien waivers so that you can send them to them. Lance, you asked about filing a motion to get a lien released. Let's just spend a minute on this because this is extremely important. Inevitably, if you're going to end up involved with real estate for any appreciable time, at some point, you're going to always have someone that's going to lien your property. Contractors believe that when they lien your property, that is sort of playing the ace of spades and they've got you totally held hostage and you cannot sell that property. I happen to have several ways to get around that. Very few attorneys are familiar with this, but under section, I think it's section 21. Is it section 27 or section 21 of the Mechanics Lien Act, Brian, where you send the notice? Do you remember off the top of your head?
Oh, that's section 24, Gary.
Section 24. All right, somewhere in between.
I take that back. Section 34. My bad. Section
34. See, this is what happens. I lose track of this. But anyway, under Section 34 of the Mechanics Lien Act, I call it, and you're going to find out I'm South Side, so I use sort of plain English here. I call it the shitter to get off the pot letter. And what the Section 34 letter is says, hey, pal, you filed a lien on my property. You have 30 days to commence suit to foreclose on your lien by filing a foreclosure on my property. If you fail to file foreclosure on my property within 30 days, by operation of law, with a wave of my magic wand, your lien will be invalid. So you have to send that notice, certified mail, and whatever Brian tells you to do, and the other attorneys in my office specifically, they'll take care of it for you. And if they don't file that suit within that 30-day period, then you can send them a notice saying you didn't file within 30 days. If you don't release the lien within, whatever time period they have set forth in the statute, then I'm going to file a lawsuit against you. And here's the beauty of it. You actually get damages. So not only will the judge sign something saying that the lien is released, but then you get a judgment against the contractor. And usually what happens is the contractors are pretty unsophisticated, and they get this letter and then they just throw it in the garbage, and then we can knock out their lien. The other way that we can knock out liens is that a mechanic's lien is only valid for 2 years from the date of filing, and after the period of 2 years, the lien is invalid. So if it's a buy and hold and you're not going to refinance, it'll die by operation of law, so it'll die of its own weight. And then the other way is if we're going to refinance or we're going to sell the asset, we can bond over the lien. So sometimes that's a practical solution, and sometimes it's not. Title companies are going to require about 1.5 times the lien amount to bond over it. So if the lien's for $10,000, we have to post $15,000 with the title company. And we do that a lot where we're, let's say somebody files a lien 2 weeks before we close on an asset. So obviously I mentioned Section 34, we got to send a 30-day notice. So that 30 days isn't going to lapse by the time we close. So we put up the 15 grand in the case if the lien was 10. And then after the closing, after the period of time expires, we get that lien knocked out. So lots of different ways to attack this. For contractors, we have other strategies to put the owners in boxes, but that's why we're lawyers. We can play both sides of the fence. It's like being a Cubs and a Sox fan. We can be both. Let's see here. I'm going to turn it over to Hugo in a second because it's a beautiful night, and I want to go sit in the hot tub for a little while. But listening and just seeing how does a sub prove they did? Okay, Kim, how does a sub prove they did any work given there is no contract between the sub and the seller? Very, very good question. If the sub is going to have their books and records to establish that they performed work on the property, and if they're liening the property, the burden now shifts to us. So they don't have to go, like when you go to the recorder's office, there is no person sitting in a window that is a lawyer. It's just a $40,000 a year employee that's taking documents and they're stamping them as long as they pay a fee. So the lien might not be valid, the lien might not be good, or it could be a piece of toilet paper. They'll take anything and they'll record it. But a sub can prove that they have a lienable interest in the property by their books and records, and oftentimes they're going to have work orders from a contractor. So they're going to have requests from the contractor via email, whatever the case might be. Hey, go over to 123 Skidoo Street, and we need 2 new air conditioners. So they're going to be able to establish that via those business records. But it doesn't have to be privity of contract, and 99% of the time there's not. Subcontractors have lienable rights under the Mechanics Lien Act, even if the owner doesn't know who they are, has never heard of them, as long as they can establish that they provided an enhancement to the property, meaning that they put something in the property, granite, countertops, HVAC, trim carpentry, roofing, whatever, they have a lienable interest in the property. Actually, not that it's relevant to our discussion now, but we've gone to the Supreme Court multiple times with mechanics lien cases. We have an attorney in our office that's the top mechanics lien lawyer in the state of Illinois, Scott Hoster. He just doesn't work past 5 anymore because he's old, but which is why he's not on tonight. But we can actually prove enhancement, so we can actually jump ahead of a first mortgage. That's how strong the Mechanics Lien Act is for contractors. So again, bank gives you a loan, a mechanics lien claimant, if the bank files foreclosure, a contractor can actually leapfrog the first mortgage holder or the bank and get paid first in a foreclosure proceeding. That's how much strength they have. The only people that have more strength are homeowners associations, which we could have another seminar on those. That's like, that's crazy. They got more power than the federal government. So we've sued those places too, homeowners associations. They're like if this was Star Wars, they're like the evil empire, the homeowners associations. Just another final thing, just because it came into my mind because I was ripping on homeowners associations. Here's a little extra. I want to call it extra credit, but it's not extra credit. Here's just a little bonus material for the 22 people who have decided to listen to me on July 27th when it's 72 degrees outside. Did you know that Gary Davidson and Castle Law have concocted a way to get around no rental provisions in homeowners associations that's both legal, effective, and allows you to give them your middle index finger? Yes, we can do that because we can create what's called the contract for deed, articles of agreement for deed, seller financing documents. All those terms are used interchangeably because even though homeowners associations have more power than the federal government, they're still incapable of preventing two private parties from buying and selling real estate. So instead of it being a rental, we can sell properties on contract for deed, which the homeowners associations cannot, are unable to restrict that. Now, here's why this is such cool bonus material. Because when we're looking to buy assets, especially now in the last year, it's been crazy for investors to be able to find any properties to buy because the real estate market's been insane. Well, it's like having a secret fishing hole, right? Because when you find out that there's communities that are no rental communities, all of a sudden, no investors are buying there. Why in the hell is stuff in Dalton, Park Forest, Chicago Heights, Calumet City, and everything else gotten crazy? I mean, I used to be able to buy stuff over there for $20,000 or $25,000. Well, because groups like Chicago REIA found it, and they're like locusts. They went over there and bought stuff like crazy, and they drove up the prices because the returns were so good. Well, we want to find secret fishing holes. Well, here's your bonus material. Find communities that are no rental communities. Guess what? That means that we've taken out a huge segment of the population that are already buyers, which is why properties in no rental communities tend to sell for less money than properties, even though these people think, oh, we got to keep these renters out. They're actually lowering their values because it's called simple microeconomics. When you take out a buyer pool, that causes depression in prices. But there you have it. No rental communities. We use a contract for deed. You can buy there. You can invest there. It's a great, great strategy. and it solves problems. Hugo, take it away. Hugo probably has his kids climbing on him. Here he comes.
Yeah, now I'm here. Thank you very much, Gary, Sergio, Brian. The information was incredible. So I really appreciate your time on an incredible evening. So thank you very much, all three of you, for your incredible support throughout the years. And everyone, please reach out to Gary. He's on our preferred partners website in Chicago, DealVault, under attorney Gary Davidson, #1 attorney in Illinois, and his firm. So I greatly appreciate Sergio, Brian, and Gary. The information was incredible. So I think it's going to be extremely helpful, and every investor should listen to what you all said tonight. And we're going to broadcast the replay because the information is so critical for every investor to know. And we had a great attendance. We reached 35 people tonight, so that was awesome. Thank you very much, Gary, Sergio, Brian.
Thanks, Hugo. We'll look forward to seeing you soon.
Thank you. Likewise. Okay, guys. Thank you very much.